Good. Hello, everyone. Very sorry for today's lateness in starting our webinar. So very welcome to joining Jiaquan IP Law's first webinar in the year 2026, how to use prior art search to address potential patent litigation risks. My name is JD, partner and patent attorney at Jiaquan IP Law. I'm very happy to be the moderator of today's webinar. In recent years, due to various factors such as political and economic globalization, an increasing number of corporate clients have encountered patent infringement disputes, either in their home countries or in overseas markets. This has not only prompted companies to resolve these infringement disputes, but has also led them to invest more time and money in patent infringement risk control and the strategic layout of their own patented technologies. Over the past few years, we have provided critical assistance to corporate clients in dispute resolution, R&D support, and patent portfolio development through patent search and analysis, particularly prior search. Today, we're very honored to invite Ms. Rony Zhou, Senior Patent Analyst and Patent Attorney at Jiaquan IP Law, to be the speaker of how to use prior search to address potential patent litigation risks. She'll share her experiences, discuss key issues, and explore challenges related to this topic. Now let's welcome Rony.
Hi, thanks JD for the introduction. I'm really excited to have this chance to dive into the topic of prior art searches with all of you today. And we've really noticed that in recent years, there's been a significant uptake in demand for this enterprise from our both enterprise clients and our fellow law firms. Since our time is limited, I want to save as much as possible for our later discussion. So let's jump straight into the main content. My presentation today will cover four main parts. The first is I will briefly explain what a prior art search is. I'm pretty sure most of you already have a basic understanding of this definition and purpose. So I'll move through this section pretty quick. And second, I will discuss the scenarios with we need prior art searches and the problems they may help solve. Third, I will use a real case to show the huge role prior art searches play in litigation and dispute resolution. Finally, and this is the key part I want to focus on today, I will show how to conduct an efficient prior art search to guarantee the reliable results. Well, a prior art search is the systematic process within the framework of patent law and identifying and verifying all relevant technical information that was made available to the public by any means anywhere in the world prior to the filing date or priority date of patent application. Of course, in actual invalidation procedure, domestic evidence may be a better choice compared to those in other languages. Additionally, patents, papers, this kind of documents with clear publication data often have stronger evidential weight than other non-patent documents. Just like the image, I think a good prior art search is like a beam of light shining into a dark place, targeting the truth. In our practical work, prior art searches can support R&D activities and help us better draft patent applications, and thereby protecting our R&D achievement and remove obstacles in litigation. But we've also observed that in some cases, a more thorough prior art search might have a negative impact on patent application. For example, when filing an US patent application, an IDS document is required. If the evidence found in the prior art search is too close to our application, it could hinder the granting of the patent. But in my view, with the development of AI and continuous upgrades to search tools, trying to get a patent by hiding prior art is becoming impossible. So the best approach is to understand the prior art as much as possible and gaining more informational advantages for subsequent patent application. When we talk about prior art searches, we may often think of searching patent documents in various languages, but I also want to remind everyone that prior art include many other categories. For example, academic or industrial publications that contain a wealth of technical information. Of course, while we need more detailed parameter information, we can turn to audio or visual materials. For example, some YouTubers conduct very detailed measurements and tears down the products, and their videos may effectively disclose the product parameters information we need. Sometimes flipping through product menus, repair menus, or user menus may also yield key evidence we are looking for. These supplementary prior art materials may not be as effective as patent documents in validation or litigation proceedings. They often require us to build a relatively complete evidence chain to prove that they qualify as valid prior art. But in other scenarios, these types of prior art are extremely helpful for supporting R&D and clarifying the boundaries of prior art. Just like I mentioned earlier, introduced 3 common scenarios for prior art searches. The first is supporting R&D. It starts with landscape analysis, letting R&D teams see what current state of the art and the mainstream solutions in the field. This detailed understanding often helps developers break through their current bottleneck. At the same time, a thorough understanding of prior art can also help R&D team avoid detours and prevent redundant development efforts. And the second very common scenario is protecting innovations. For example, before filing a patent application, a thorough prior art search can help determine if the technical solution has enough novelty and enough inventiveness. It provides decisive information on whether to proceed with the patent application. Additionally, by analyzing prior art, we can better focus on defining a reasonable scope of the protection for the claim. We want the scope to be as broad as possible for better protection, but also avoid making it so broad that's easily invalidated. And in third scenario, I think this is the one most commonly encountered every day, is using prior art searches to reduce infringement risks or address litigation.
Hello, Rony. Sorry to interrupt. Hi, Rony. Yes, it
Mm.
seems that you have not changed any slides on your side.
So,
because we can only see the page 1. That's
Page
your
1.
self-introduction. Yes, now it's page 5. Is that correct?
Yeah, it's been
Okay.
delayed, I think. Maybe I can share again.
All right.
Which page?
You may just continue because we will share these slides to our audience later.
Okay. Which slide do you see right now? Want to
Page 6.
initiate? Page 6. want to
Yes.
initiate a prior search, right?
Yes.
Okay. So we can see the third scenario. The one most commonly encountered is using prior searches to reduce infringement risks or address litigation. First, during FTO investigations, we sometimes find high-risk patents we cannot avoid. At this point, prior searches help evaluate the stability of these risky patents, thus assessing their actual litigation risks to us. And second, if we face litigation, prior searches can uncover strong evidence to file an invalidation proceeding by fundamentally invalidating the risky patents, and the associated litigation and dispute are naturally resolved. Now I'm going to switch to next slide. Okay. JD, could you see the next slide, page 7?
Not yet.
How about now?
Still on page 6.
Page 6.
Now it's okay. Page 7.
Page 7. Okay, good. Let me provide 3 specific situations for the third scenario. First, in section 337 investigation, the time is very, very tight. On one hand, we need to carry out design round for the product. On the other hand, we also need to consider filing non-infringement defense or prior defense. And the second situation in patent, okay, the second situation in patent infringement lawsuit, strong prior art can be used to invalidate the plaintiff's patent, ending the dispute as its root. And the third situation is when enterprise face exhibition seizures at trade shows or platform removals on e-commercial platforms. This is more like a channel blockade. At such times, we need to immediately provide documents providing that our products do not infringe patents or that they belong to prior art to get the product back on the shelves as soon as possible. That's why it's crucial to conduct a prior search before participating an exhibition or launching products online. Maybe I can share again. Okay. We believe prior search is one of the most optimal solutions because it can extremely cost-effective business decision. As we all know, winning a patent lawsuit in any country comes with high cost and risks. However, if we can find evidence that undermines the foundation of the plaintiff's patent right through precise prior search, we can fundamentally solve the problem. I personally experienced a lawsuit last year. At that time, the client we represent was the defendant, and the case between them, and the case has gone through to the final trials. And our client was ultimately ruled by the court to have infringed and requiring compensation for several million RMB. In fact, before this, we had already tried to invalidate the patent, but in the first proceeding, we failed. However, we didn't give up and continue searching. eventually we found some very useful, very good non-patent literature evidence. We found a set of pictures online of product images published on plaintiff's official website from 10 years ago. And this publication date of this set of images was earlier than the filing date of the patent, constituting very intuitive prior art for the involved patent. Therefore, through these two sets of website photos, we successfully invalidated the involved patents, thus preventing our client from having to pay millions of RMB. Oh, okay. Let's move to a real case. JD, could you see the case study slide?
Not yet. Rony, we cannot see the full screen of your presentation.
I'm already in my full screen on my side. I think there is a huge delay on the internet.
Yes, a little bit. We're now still on page 8. Okay, now page 9.
Page 9, case study, right? Carco's response to NOCO. Good. Okay, this is a real case that occurred after 2021 in automotive emergency jumpstarter industry. Chinese company Carco was hit by a Section 337 investigation initiated by U.S. company NOCO. And in this investigation, along with Carco, 12 other companies were sued. At that time, we provided prior art search services for one of these companies. Carco's strategy was highly sophisticated. They proactively initiate IPR at the PTAB before the opponent formally launched the investigation. And the final result was that NOCO's core patent was declared invalid, and the intersection investigation ended accordingly. And this successful invalidation not only saved Carco, but also protected 12 other companies. It's worth noting that because the cost of Section 337 investigation are often extremely high, a single company can hardly afford them. So in many cases, the sued companies will join together to form an alliance to fight collectively. They share resources, they share documents together to win the case together. Okay, so going back to when the case happened, we didn't find very useful evidence during the patent search. The turning point is came from our Canton Fair manual, which was a product brochure distributed to the participants at the exhibition back then. The brochure clearly disclosed all important technical features of the patents and forming a complete and direct chain of evidence. But the legal battle had just begun. The opposing side fiercely attacked the public accessibility of this evidence, meaning they refused to recognize it as a printed publication under US patent law. So what made it more dramatic was that the scheduled key witness was unable to appear. As a result, an alternative witness who was present at the time had to court. With his personal experience and on-site photos, he finally convinced the judge to confirm the legal validity of this brochure. I think in court, proving the public availability of non-patent evidence with strictness is the key to winning, but finding such evidence is an indispensable foundation. It seems okay. Okay, how to conduct a high-quality prior search? We usually divide it into 4 stages. The first stage is patent analysis, and the second is systematic searching, and the third is combining and evaluating the retrieved evidence documents, and the fourth is conducting supplementary searches for any missing technical features, followed by documents writing and preparation. So in the first stage of the patent analysis, what we usually do is conduct an in-depth analysis of the technical solution of the patent. However, I believe that in actual operation, it is also very important to carefully analyze its patent examination history, which help us determine its inventive points and its actual scope of protection of the claims. And at the same time, we also need to clearly understand the technical solution of the accused product, because sometimes the scope of protection of patent claims is very broad and may cover multiple solutions or embodiments. And our accused product is just one of them. Therefore, understanding the product and then conducting highly targeted searches help us obtain the best evidence. And the second stage is the crucial search phase. Initially, we usually conduct a tracking search to obtain documents such as those from the same inventors or applicants as the patent, and the reference documents used during the co-pending examination of the involved patent. This process helps us quickly and efficiently identifying key search directions. And after the tracking search, we conduct a systematic search, which is most people are familiar with constructing search elements using keywords and IPC or CPC numbers. Well, after the second stage of searching, we usually have a lot of evidence on hand. And how to use this evidence actually require us to invest a lot of effort in consideration. We usually provide multiple evidence combination from different perspectives, such as perspective of patent embodiments or the accused or the perspective of accused product, and announcing the advantages and disadvantages of using different combinations, especially in most invalidation procedures. And we can provide multiple combinations to achieve the maximum possibility of patent invalidation. And I think the final step is to conduct some supplementary work, some targeting points that may not have been fully disclosed in the previous evidence, and we can expand our search scope or switch our search strategy. And after doing all this work, we can proceed with document preparation work. Well, I believe the part everyone is most focused on is how to conduct a systematic search. Based on my practical work experience, I have summarized 3 principles for searching, which is from easy to difficult, from precise to broad, and from native language to foreign languages. So the first one, from easy to difficult, can be simply understood as starting with simple, most direct, and easily accessible information to quickly build our initial understanding and reduce the difficulty of getting started. Well, the second principle, from precise to broad, means we can first accurately locate the scope of our core patents and then gradually expand our search scope while balancing the depth and breadth of the search. Well, the last one, from native language to foreign language, refers to arranging our search reasonably according to the regional characteristic of our technical field to improve search efficiency. Well, of course, from native to foreign is more suitable for Chinese searches because there is a larger amount of Chinese prior art in the database, and searching in Chinese prior art often give us good evidence. However, some technical fields may have developed earlier in some specific countries or regions. And in that cases, we may need to consider the specific situations of the technical route and start from a specific language before expanding to other languages. Well, let's dive deeper into the first principle from easy to difficult, starting with tracking search. And tracking search begins with the involved patent, extracting key information like inventors, applicants, and the family patent examination histories. You can also track references in the patent's background section or cited reference in its specification, and this often lead to highly relevant prior art. And I think tracking inventors and applicants and checking their other patents, research papers, or even collaborators. Academic inventors sometimes publish papers before filing patents, which can serve as early prior art. This tracking quickly builds a list of core keywords and classification numbers for deeper searches. Well, through the previous step of tracking search, we can often determine the core IPC most relevant to the patent. Then we can look at surrounding IPC numbers around this core and incorporate other relevant data in our consideration. And after confirming this classification numbers, we want to use, and we need to consider which keywords to use for searching. My suggestion is in the initial stage, we can reuse some of the terminology expressions from the patent and to construct a precise search strategy. And this way we can obtain the most relevant batch of data quickly. For the principle two, from precise to broad, I believe that relying solely on tracking searches or using very specific keywords may give us some evidence, but it's not enough. So we can use the principle from precise to broad, and we should gradually expand our search scope. And we can expand keywords and classification numbers, and then use these grammar rules in a database, such as proximity operators to make our search expressions more precise, while also expanding their scopes. Since our search principle is from precise to broad, we must first construct the most precise search formula. After building our keyword and classification numbers into search elements, we should use the very strict search condition, which is the AND logical operator, to combine all our search elements together and obtain the most promising data. When the precise search results are efficient, we can try to gradually replace or reduce some our search elements, but guarantee the most important ones due in our search formula. And the last step is to dynamically adjust our search formula. For example, we can extract more effective keywords from some excellent comparison documents we found, and then we use this like reverse engineer and revise our current search formula. The second commonly used method is to correct field biases in fields like medical devices. There are often some specific keyword expressions for particular products and subfields that we might need to adjust for. When making dynamic adjustments, we can also consider expanding or revising keywords related to technical effects or the technical problems being solved. So for example, if a patent focus on reducing energy consumption, we might expand this to include lower power usage or energy efficiency improvement to capture more relevant documents. Well, when applying the from native to foreign languages principle, for example, starting by conducting a thorough search using Chinese keyword and classification numbers in domestic patent database, extract core technical terms, applicant names, and precise IPC from the most relevant Chinese patents we found. And then we can translate these elements into other languages, other patent terminology, and use them to construct search formulas for foreign database. I think when searching for foreign patents, we should consciously increase the use of classification numbers, leveraging their globally unified technical classification system allow us to accurately locate the prior art we need. And this effectively solve problem where keyword translation are not inaccurate enough in foreign patent database. Well, that's all I would like to share with you. To wrap up this webinar, I would like to briefly introduce our search team. We have extensive experience in patent searching across fields like medical devices, semiconductors, displays, and household appliance. And we help numerous clients find crucial evidence and giving them an edge in legal disputes. And please feel free to stay in touch with me and to discuss any search and analysis needs you might have. Hi, JD.
Hello.
Yes.
Thank you, Rony, for the wonderful presentation. Now is the time for Q&A. If anybody has a question, please feel free to raise your hand.
Because of the internet, I think maybe you can text your question.
Yes, and you can also put your questions in the text box. We received a question from William. Hi, any preferred tool for searching patents?
Yes. We always use commercial database to do the patent search. In China, we always use PatsNap, PatsNap, and IncoPat. These two tools are very efficient and user-friendly, I think. Sometimes we also search non-patent literature in YouTube or Google Scholar.
Thank you. And we also have a question from Queen at Ken Fox. Could you please share with us the tools you are using for searching?
Yeah, this is the same question, I think. Well, I think I heard there are some AI search tools recently. It's free and you can ask a trial. But I think their search strategy is totally different from PetSnap, IncoPet, or Google Scholar. Maybe you can have a try. I think the website is called sorry, I forgot the name. But if you are interested, I can write it in the email.
Okay, thank you. And now we have one more question from Jason Morgan. What process do you use to help prioritize prior art? I would assume in some
In some cases, there could be a flood of potentially relevant prior art. I think that's a good news. That means you have enough evidence and you can choose some really good one, some really perfect evidence from it. I think it's like in my previous slide, I will give 2 or 3 combinations of evidence. The first is according to the protection scope of the claim. I will give a combination that most close to the claim itself. And the second combination is a combination that close to the product, because maybe the product is just one form or just one way to realize the claim. So I think that's the way I chose my evidence. And I always use maybe the prior art of the prior art from the same patentee is also a good choice, because they share the same R&D route. Maybe the judge is easier for the judge to accept this kind of prior art. Any questions?
Okay, any other questions? If no, we are going to close the webinar today. So thank you very much for your joining, and we will share the slides and recording after the webinar. Thank you so much for joining us in today's webinar, and we hope you have a lovely rest of the day. Thank you, Rony, and thank you, everyone.
Thank you. Thank you, JD.
Thank you. Bye-bye.
Bye.